Justice Thomas, claiming that the entire argument is complete garbage, he says, hey, look, the ATF could legitimately say, since machine guns are illegal, and since an AR-15 lower receiver is almost a machine gun, therefore all AR-15s are now going to be regulated as machine guns, and since you don't have the proper documentation, you can't own an AR-15. Now, in today's video, we're going to be talking about the recent decision in Bondi v. VanDerStok. This is unfortunately a loss, and you have probably already heard about it. But I do want to go into a really interesting sort of nuanced aspect of it. And hopefully give you some cause for maybe some hope in the future. That being said, this is the ghost gun case. This is one of the ones that we were hoping, to be quite candid with you, would reinforce Bruin and start moving away from behavioral-based gun control legislation to hardware-based gun control legislation. I'll explain that concept in a couple of seconds. First and foremost, this decision was authored by Justice Gorsuch, which is quite odd. All right, Justice Gorsuch is, in fact, a constitutionalist. This might, frankly, explain one of the reasons why he authored the opinion, not because of extreme advocacy for the Second Amendment. Rather, I would suggest that his advocacy for the way the Constitution is structured actually took precedent over the Second Amendment. Now, he does say something in the opinion that is incredibly disingenuous. I don't want to let him completely off the hook on this one, but he is typically oriented towards the idea that the way the Constitution is structured should sort of constrain the judiciary. In this particular aspect, the plaintiffs challenging the 1968 gun control law that requires serialization for frames or receivers claimed that the Biden administration's new advisory from the ATF suggesting that a parts kit on something like a Glock or an AR-15, that parts kit should be a regulated part, that it should be serialized, and by being serialized now requires an FFL for a transfer. I know that gets a little wonky, but effectively it would eliminate 80%ers in their entirety, or at the very least would eliminate the benefit, quite frankly, of having an 80%er in the sense that it would be unserialized. Now, the plaintiffs challenged the law as being facially invalid, essentially making the argument that from a facial context, there is no way, under any way, shape, or form, that the Biden administration's argument that a partially completed frame or receiver should require a serial number could never be constitutional. Effectively, when you challenge a law, you either do it what we refer to as an as-applied challenge, meaning that the law as applied to our client is unconstitutional, or alternatively, you can do it as a facial challenge. A facial challenge is far more burdensome. What you're essentially saying is it can never be constitutional under any rubric whatsoever. Because this was brought as a facial challenge, Justice Gorsuch seems to be really oriented towards the idea that the challenge is going to fail. Now, more importantly, he essentially says, look, there's no getting around this. Congress authorized the ATF to develop rules and regulations in order to promulgate as well as explain the the 1968 Gun Control Act. Okay guys, I'm going to pause this video for just a second. USCCA, which really kind of produces these videos for me, they are doing a giveaway right now. It's pretty exciting stuff. You're going to want to get on it. You can read all about it in the comments or the description below this video. Okay, with that, let's get back to this video. Now, this is somewhat interesting, and it's not really brought up, but we had a Supreme Court case last term where something along these lines was specifically challenged, and the court essentially took away this power. So there is somewhat of a disconnect in this. What's also interesting is that while Justice Gorsuch seems to suggest, look, there is no real functional difference between an almost completed receiver and a fully completed receiver, Justice Thomas, who issues a dissent claiming that the entire argument is complete garbage and in fact relies on Bruin's history, text, and tradition approach, says that the majority got it wrong. And by the way, the majority is a super majority in this one. This was a 7-2 decision. The vast majority of the court agreed that the ATF should be able to regulate partially completed receivers. Now, Justice Thomas and Justice Gorsuch sort of go back and forth on this. In Justice Thomas's dissent, he says, hey, look, by using this standard majority, so the ATF could legitimately say that since machine guns are illegal, and since an AR-15 lower receiver is almost a machine gun, therefore all machine guns, or excuse me, all AR-15s are now going to be regulated as machine guns. And since you don't have the proper documentation, you can't own an AR-15. Now, Gorsuch says something in the opinion that to me is probably the single most troubling aspect of this. To quote him specifically, AR-15 rifle is machine gun because it is possible to convert those receivers. This is what Justice Thomas says. That result, the plaintiffs warn, would leave many Americans facing new unforeseen criminal liability for possession of a machine gun simply because they own a popular and commonly available rifle. The plaintiffs' fears are misplaced. The government represents that AR-15 receivers do not qualify as the receiver of a machine gun, nor, the government emphasizes, has ATF ever suggested otherwise. Now, the reason that I call this out is because of a huge body of opinions that Justice Gorsuch has written specifically favoring Native Americans. Justice Gorsuch seems to have a constitutional soft spot for Native Americans and has held the government at bay for its mistreatment of Native Americans. And throughout the course of our history, our government dealing with Native Americans, we have consistently made emphatic promises to them, which we subsequently reneged on. And Justice Gorsuch has read them, acknowledged them, and used these reneging of agreed upon ideals as part of his other opinions. So for him to now suggest that because the government has said we have no intention of regulating AR-15 receivers as machine guns, I think is disingenuous at best. Now, with all that being said, this case, while, it takes away the ability for us to be able to buy unfinished lowers and not have them serialized, it does not implicate the Second Amendment in its entirety. Now, like I said, this case was a disappointment, not simply because we wanted to have people have the ability to have unfinished lowers. Okay, I mean, that obviously is the thing. What we were really interested in is getting a ruling that specifically moves away from behavioral-based legislation and moves into hardware-based legislation. Whenever a gun control statute is created, it's going to fall into one of those two categories. It's either going to be a behavioral-based restriction, like concealed weapons permits, right? If you want to carry a gun, you've got to go through these sort of administrative hoops in order to get a concealed weapon to carry a gun, right? That is a behavioral-based restriction. Alternatively, there are hardware-based restrictions. These would be things like, whether or not you can own an AR-15, or whether or not that Mega Blaster 3000 is legally available to you, things along those lines. More specifically, we have things like standard capacity magazines and the like. Now, there are a couple of cases that are up for review. We've talked about them before: Ocean Tactical v. Rhode Island and Snope v. Brown. These are hardware-based cases that, to a large extent, are going to determine whether or not these products. In Ocean Tactical, we're looking at standard capacity magazines, and in Snope v. Brown, we're looking specifically at AR-15s, whether or not these items are in fact in common use and therefore protected by the Second Amendment. We were hoping that the VanDerStok case, since it was a hardware-based restriction, you cannot buy an unfinished frame and receiver without having it serialized, we were hoping that this would sort of circumvent the whole Snope v. Brown issue and give us a ruling now, really kind of defining common use so that it could be used for other cases that are currently in litigation. That clearly did not happen. Now, whether or not this should be interpreted as the court stepping away from the Second Amendment, I think is probably a little too aggressive. I've seen other commentators make that statement. I think that, like I said, I just don't see that right at this point. What it might be is the Supreme Court beginning to coalesce around the idea of allowing a certain level of federal government control, where they might have been more resistant to do so under a previous administration, but are now amenable to doing it under the Trump administration. I find that also, frankly, very troubling. It may be exactly what's taking place, but this is a dangerous precedent to say the very least. Now, again, whether or not this has long-term ramifications for the general Second Amendment community, that remains to be seen. We're still hoping for a decision in those two other cases that I mentioned, but clearly, as it stands right now, the ability to acquire a unregistered parts kit and finish off the lower receiver and make it into a fully functional firearm, and to be able to do so without having a serial number attached to it, that seems to now be foreclosed. Anyways, if you have any questions or you'd like to get more information on this, of course, you can do so by emailing me directly at steven@artemishq.com. As always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.